Hello, my name is Imelda Reddington. I'm Head of Immigration here at Field Seymour Parks, and today I'm going to take you through the immigration changes for 2020 and beyond. There are 4 parts to this webinar I'd like to discuss with you. First of those is the newly elected majority Conservative manifesto, the new immigration system, and then I will look at what we know about Brexit and the EU settlement registration scheme, and then finally a quick look at the right to work checks. So with the newly elected majority government, they intend to look at creating an Australian-style points-based system. Now, I've given Australian here, but there is also a similar system in Canada. And I understand at the moment our government is initiating talks with representatives of both of those countries to establish whether or not the points-based system will be suitable to use to operate in the UK. So that's ongoing at the moment. With our Brexit date heading ever nearer on the 31st of January, there is an intention that European nationals will be treated equally to non-European nationals. So the points-based system, the new system, will also cater for those, for all individuals. The Conservative manifesto also said it will prioritise people who have English language, no criminal records and a good education, and will prioritise industries that we require to fill skill shortages within the UK, with the intention of promoting and investing into the UK economy. So there was some detail set out in the manifesto about the new immigration system. We don't quite yet know what it will look like. However, it is due to come into force on the 1st of January 2021, which will coincide with the end of the transition period for European nationals and their family members. So it's effectively a points-based system that will encompass 3 separate routes for working individuals to come into the UK. I will look at those in a little bit more detail shortly, but the new immigration system also identified that there was some governance required. Over the past 10 or so years, the government initiated ad hoc advice from the Migration Advisory Committee. It's been established that there is a need for more advice on a more regular basis. So again, I will look at how the government intends to incorporate the MAC into the day-to-day running of the new immigration system. And finally, the new immigration system will be digital in nature. It is intended to be able to count people in and out of the UK to establish how many migrants are those in the UK under an immigration control at any one time. So let's have a little look at the types of routes that will fall under the new immigration system. There's one called the exceptional talent, and this will replace a number of existing routes that are designed for those who want to come to the UK without an existing job offer. So it's designed to recognise leaders or emerging leaders in their fields of expertise. And there is an intention to make it a fast-track visa with lower visa fees. It's designed to attract investment into the UK. And there's also an intention to expand those bodies who are currently authorised as endorsing bodies for individuals in this route. It's recognised there isn't really enough. So the UK RI and many other bodies will be capable of endorsing candidates to be able to come to the UK under this exceptional talent route. There will be no cap on numbers, and dependents or family members of those who will be deemed eligible for this route will be able to work without full access to the UK labour market. So yesterday there was a new route announced by Boris Johnson, which will replace the Tier 1 current exceptional talent route. We don't quite know the detail of this route. We are told that the route will come into force on the 20th of February, which is just a couple of weeks after the Brexit date, and some believe that it's just a softening for those who are currently in the UK as researchers or scientists. There are 2 other categories for those who want to come to the UK to work. One we have already under the Tier 2, Tier 5 scheme will now be called a skilled workers category. We believe that sponsorship will remain the key requirement. So it remains to be seen whether or not those who want to employ European nationals after the end of the transition period will be required to obtain a sponsorship licence. We expect that will remain key. The skilled workers will also need a confirmed job offer to come to the UK. And as with the Australian type points-based system, additional points will be awarded on the type of role that candidate is coming to fulfil. So those with a job offer will have extra points. There is perhaps a possibility that those who want to come to the UK will be able to come without a job offer, but until more detail in relation to the scheme and the new rules are enforced, we cannot yet confirm whether that will be the case. Under the skilled workers route, the MAC or the MAC will advise on caps, and they will also be there to establish whether there's any shortages or whether businesses have identified any need in specific areas across sectors. There will also be the usual requirement of English language, no criminal record into the UK, and Boris Johnson has identified that he will be capable of setting out specific visas for identified areas in the UK that there's the most skills in shortage, and one of these has been recognised under the NHS. Now, for many years, the NHS have argued that there is a shortage after advertising for months and months on end to fill specific roles. So finally, it's been proposed that perhaps there could be a specialist NHS visa which could fill doctors, nurses and health professionals. We're assured that there'll be no cap on the number of qualified individuals in these three categories coming into the UK, and their family can join them without any restrictions to enter the UK labour market. So that's great work. That's great news, and this really opens up the possibility of expanding this skilled worker category for other areas. There's a potential perhaps to have an area for IT workers or construction workers or other skilled workers, perhaps not construction, perhaps those mainly in higher skills, but there's certainly an opportunity for IT workers and others of that nature moving forward. There is also a third category called sector specific. We don't quite know what this means just yet, but we have been given a summary to say that there will be no route for unskilled workers into the UK. However, having said that, about 18 months ago, the Home Office, with some pressure from specific sectors in the UK, established an agricultural scheme because of the need of fruit pickers and vegetable pickers in the UK. There was a visa which was a seasonal visa, and this was removed, and therefore the agricultural industry felt that they had no way in filling these shortages. So a pilot scheme was set up and is currently operating for 2 years. The Home Office agreed to have a cap on the numbers for the first year of operation. Now, this is the first year of operation, and 2,500 places have been approved for the start of the scheme. We've just heard that this has been increased to 10,000 places for 2020-2021. So it does demonstrate that with a little bit of pressure on the Home Office from each of these sectors, that the Home Office will listen and, provided on the evidence that's made available at the time, they will listen to where the skills shortages lie. There is scope for other sectors to set up in this nature. One I'll use is hospitality, and the other is construction. There was something in the press 2 weeks ago about a shortage of skills in the construction sector. If there were the same kind of pressure applied from that area of industry, then perhaps the Home Office together with the MAC could devise a similar scheme. Also in the sector specific route is where the schemes for short-term visits for work, business and various assignments will fall. At the moment, we have very restrictive rules for those who want to come to the UK for business visits. There is a restriction on taking anything that's deemed to be employment and client-facing meetings. So we will see how the Home Office will make it a little bit easier for businesses to bring workers across for short assignments. We don't yet know, as I say, what it'll look like, but provided, I expect there is no threat to the resident labour market, I expect they will have a scheme that will be beneficial for employers in the UK or international employers. Now it's said that these sector-specific routes will not lead to settlement, so they will be temporary in nature, and I expect them to look something like what we have already for temporary workers, with a maximum period of 2 years permitted in the UK. At the end of that 2-year period, I do suspect those workers will be allowed, or those migrants will be allowed, to transfer to another route, which will then lead to settlement possibly. So in terms of what the MAC will be responsible for, I indicated at the start of the webinar that the MAC were, in the past, instructed to provide independent advice on an ad hoc basis to the Home Office. It's established that this perhaps is not enough, and the Home Office and the government would like the MAC to be there on a more permanent basis. So the MAC will now be required to produce an annual report to identify how the government can lower overall immigration to meet the needs of the UK economy and to improve the UK's productivity. The Home Secretary will continue to appoint a committee and provide resources as required for the MAC so that they can pursue this role. However, it does look like that the MAC, with the assistance of business sectors in the UK, can perhaps advise the Home Office in a more appropriate way than what they currently do. And the final aspect of the new immigration system will be that it is designed and it's intended to be digital in nature. However, we do have to wait some time before this digital operation will come into force. It's expected to come in from around 2022. And at that point, it's expected that our immigration system will have the capabilities of counting migrants in and out of the UK, so that we are aware, or the government is aware, how many migrants are in the UK at any one time, with an aim to managing immigration control. We're assured that data protection will be of the utmost importance. But again, we have some time to wait for this, so we'll wait and see how this progresses. Now I'm going to talk about 2 further subjects, one very close to people's hearts at the moment, and that is Brexit, which our exit day is pending. It's a matter of days away now, heading for Friday the 31st of January. Really, I want to talk about the European Settlement Registration Scheme. We now know that a deal has been passed. It's gone through the House of Lords and it's now become law. It received royal assent at the end of last week. There were a couple of amendments proposed to the House of Lords, and it's understood that the government haven't accepted any of them. One of them was that European nationals should have the ability to request a document showing their right to reside in the UK. This unfortunately has not been accepted. And this really falls in line with the intention to have the entire system digital in nature. So currently, the EU settlement scheme provides registration in a digital format, which can be shared with employers, and this looks like it's the way we will go forward. So the intention really is to have the registration of the European Settlement Scheme completed by the 31st of December 2020. So all European nationals, now I say European nationals, and this also includes Swiss nationals and those who fall under EFTA. If they want to remain in the UK beyond the 31st of December 2020, they must now look to register in the scheme. The transition period will end, and it's been set in legislation that it will end on the 31st of December 2020. So we have until that time to do so for your employers to start asking their employees to either provide a status under the EU settlement scheme to show settled or pre-settled status, and then this check can be taken as a right to work check, protecting employers moving forward from all of those civil and sanctions that the Home Office can impose. There is some mention of a leave called European Temporary Leave. Now this came about back in March 2019, and it was repeated again in October 2019. And it was, if we were to leave without a deal, what kind of leave could European nationals have if they wanted to come to the UK during the transition period and beyond. The leave exists under the immigration rules. We don't yet know if it will be implemented, but the intention is European nationals can continue to come to the UK for up to 2 years, provided there is a reciprocal arrangement with the other states. We don't exactly know how this will work just yet, because we leave in a matter of days, and then it's the negotiation starts with the other states to ensure we have reciprocate arrangements with for the UK nationals residing in those states. And the final point I'm going to cover is right to work checks, which of course affects all employers across the UK. Civil and criminal sanctions will be imposed if an employer fails to prevent illegal working and obtain a right to work document demonstrating the right to work on the first day of employment. If the employer conducts this check and records the information accordingly, they will then obtain something called a statutory offence. And this statutory defence can be maintained provided the initial checks and repeat checks are conducted appropriately. Now, the initial and repeat checks encompasses a whole host of other issues, including whether or not that migrant has the appropriate right to work and whether the conditions of their visa means they can work for the appropriate periods, the appropriate hours. So a word of warning here for those who employ students. If a student is only allowed to work a certain number of hours a week, then you must put processes in place so that you can identify and establish whether that student is going over those hours. And the last point I was going to cover is in relation to the online checks. And again, this is reiterating the fact of using a digital system moving forward, which I know lots of you employers will be delighted to hear. The online checks came into force on the 28th of January 2019. However, there are only a couple of instances where these can be conducted. They're not mandatory at the moment, but they are optional and can be used to establish a statutory defence in the right to work legislation. At the moment, it's only non-European nationals who have a current biometric residence card, so that is that little pink card, which is very similar to a driver's licence, and those EU nationals with settled or pre-settled status under the European Settlement Scheme. The EU nationals in particular will have an online right to work status, which is sent to them in an email from the Home Office. Once they go into this link, there is a facility for the EU national to share a code with their employer, and the employer can then access a record of that EU national and take a copy, a PDF, and indicate and diarise that they have undertaken a right to work and file it on their HR file. This is then establishes a statutory defence and avoids any civil or criminal sanctions under the right to work legislation. As I said, between now and the end of December, nothing really changes. The right to work checks can still be undertaken using paper documents, provided they are set out in the guidance under the right to work legislation. So don't worry if you're not obtaining any of the online checks at the moment. You can continue using paper. The end of the transition period, things will change, but for the moment, it's status quo. And that concludes my points. Obviously, this is only a very brief introduction and summary. If you have any specific circumstances, you should take separate legal advice on your own circumstances. However, if you would like any specific advice, please do get in touch. And if you have any feedback or suggestions for our future webinars or training or seminars, please do get in touch with us. I'm Imelda Reddington at Field Seymour Parks in Reading. Thank you.